Hey, Paul Rabelais here, and just some thoughts because I've been dealing with some issues lately about leaving things to young people. So, the one thing that you should never do is name a young person, and a young person could be a minor, for example. Never name a minor as a beneficiary or a contingent beneficiary of an IRA or a life insurance policy or a 401k. A lot of working people have 401ks. They have minor kids. They name their spouse as the primary beneficiary. If they're married, they name their kids as the contingent. It's a mess when a minor is named as a beneficiary. And also, you don't want to leave things in your will to a minor. And a minor could be a child, it could be a grandchild. So here's what happens if a minor is named as a beneficiary on a life insurance policy, IRA, 401k, and the account owner dies, leaving things to that minor. Well, the company isn't going to pay a minor, so they're going to hold on to the money, and they want to see all these court documents before they'll release the funds. So what has to happen? Somebody has to hire a group of lawyers. We have to go file these petitions at the courthouse, and we have to ask a judge to name a guardian of the minor. And so let's say dad dies, his 3 children are minors, and they're named as the beneficiaries on his 401k. And so somebody has to petition the court to be named the guardian or tutor of the minors, and all kinds of court things happen, but ultimately a courthouse issues orders. And then what happens is the money goes to the court-appointed guardian, and the guardian has to account to the court every year as to how that money was used for the minor. And if the guardian wants to spend any of the money on behalf of the minor, pay their education, buy them housing, clothing, whatever, a judge has to approve that expenditure. And then on that minor's 18th birthday, then the court-appointed guardian is responsible for turning over all of those funds to the former minor, now 18-year-old adult. Happy birthday. So then the 18-year-old gets a big windfall, and who knows what happens to the money next, but probably new boat, new truck, new wardrobe, whatever, not probably used responsibly. So what most people do to avoid all of that is have all of the estate planning legal documents structured so that if and when things go to the children or to the grandchildren or to the young people, whoever that might be, it goes into a trust for those young people. So let's say dad has a house and he has a will, he leaves things to his children, they're minors, difficult court proceedings, but if he leaves things to a trust, maybe he names his sister, maybe he names his wife, let's say he's not married, maybe he names his sister, the children's aunt, as the trustee of the trust for the minor children, dictates in all of the trust instruments that if the sister needs to use the money left in trust for the children, if the sister needs to use that for the children's health, education, maintenance, and support, she can use it. And then he designates that at certain points later in life, the children then get the remaining funds. And that could be done a number of different ways. It could be done when they reach a certain age. When our children reach the age of 25, then they can have whatever is left of their share. Or they can get a third at 25, a third at 30, a third at 35. Or some people say, I want my child to get X amount per month or per year until it runs out. Some people say, I want the trustee, I want my sister to have the discretion to determine when my children are old enough and responsible enough to handle it for themselves. Then my sister can turn it over to them, but not until then. And that gives put some protections in place in case the children aren't yet ready to get a lump sum of money at those certain ages. The sister can hold on to things and give it to them later when they're ready. So all of those things come into play when somebody is setting up an estate planning legal program, and there's the possibility that young people, perhaps minors, perhaps children, perhaps grandchildren, perhaps great-grandchildren, are included in that estate planning program, you always want to make sure that things go to a trust so that they don't get tied up in a court proceeding. It doesn't get dumped into their lap at age 18, and it gets used for the right reasons and doled out at the right times so that it's really can benefit people for the rest of their lives, and no big mistakes are made at early ages when someone perhaps is not mature enough to handle that. So if you want to know more, shout. Have a great day.